Good morning, everyone, and welcome to the McCarthy Presents episode 5 in partnership with SFIPLA today. We are going to kick off our session here in just a moment, but first I have 3 housekeeping items for you. First, be sure to jump into the chat and let us know where you are joining us from. We have registrants from all over the Bay Area and beyond, so be sure to give us a shout out, let us know where you're joining us from. Also a reminder, our panelists will be addressing your questions live at the end of today's session. So feel free to ask your questions using the Q&A feature. And if someone else has already asked the question that you wanted to pose to the panelists, go ahead and use the upvote feature to pull that to the top of the list for them to address during our Q&A today at the end of the session. Finally, before we turn things over to our moderator, for those of you that are registered and attending today, we will be issuing out a California CLE certificate via email following the session. So you don't need to do anything on your side. We'll go ahead and send that email to you automatically and include that certificate for your CLE credits. With that, I'd like to turn things over to our moderator, Staphanie Hall, to take things away today.
Thanks, Kelsey. Hi, everyone. On behalf of the San Francisco IP Law Association and the McCarthy Institute, I want to welcome you to today's panel on trademark law and its challenges 2020, US and Europe. This is obviously not a complete overview of trademark law challenges. There are plenty of those, but just a curation of topics covering both sides of the Atlantic. We've got some great programming set up for you today, and I'm excited to see so many participants. I'm going to quickly introduce our panelists before we kick things off. First, you'll hear from David Franklyn, the director of the McCarthy Institute for IP and Technology Law and a faculty member at Golden Gate. Then we'll go to Vijay Toke, a member of Pillsbury's IP practice, focusing on trademarks, copyrights, and licensing matters. Last, we'll shift gears going across the Atlantic with Nick Aries, who's an IP partner with the international law firm Brid, co-heading that firm's San Francisco office, where he advises on EU and UK trademark, copyright, design, and trade secret matters. It's a lot packed into a short amount of time. So as Kelsey mentioned, we're going to save all the questions for the Q&A at the end. Be sure to use the Q&A chat function to submit them throughout the panel. If you see a question already asked that you'd like to see answered, use the upvote or the thumbs up button to make sure we see that. We'll start things off back with David, who's going to be discussing key takeaways from 2 of the big US Supreme Court cases this year, Romag and Booking.com. David, I'll pass the mic to you.
Thank you, Stephanie. Hi, everybody. It's David Franklyn here. You've seen me before. My goal today is to spend a short amount of time giving an overview and considering the implications of 2 Supreme Court cases, US Supreme Court cases, dealing with trademark issues that were handed down by the Supreme Court recently, or relatively recently. One, as you see listed on your screen, is Romag Fasteners versus Fossil Group, and that decision came down in April of 2020. The other case is the USPTO versus Booking.com, and that one came down in June of 2020. Next slide, please. I would like to just, before jumping into Romag, I'd like to make a couple of comments. For those of you who have tuned in before to the McCarthy Institute series online, you would probably have noticed that we've done independent, full-length podcast/webinars on both of these cases, where we spend about an hour and 10 minutes doing a deep dive into each of them. And those webinars are archived on our website and also on YouTube. And because of that, I would direct you to those if you would like to do a deeper dive into either of these cases, a deeper dive than I have time to do today. But for those who haven't watched those, I thought it might be useful, or we as a group thought it might be useful, given the overall global topic for today of being recent developments in US and European trademark law, for me to at least do a cursory overview of these and within the time afforded. So I'm going to spend about 15 minutes doing that, maybe about 7-8 minutes per case, and then pass the mic, as it were, over to our next speaker. All right, so let's go ahead and start with Romag. Some people have said that the facts in this case are not nearly as important as the sort of the central holding. Central holding, as probably a lot of you know if you're trademark lawyers, is that the Supreme Court resolved a circuit split and in the federal courts and said that willfulness is not an absolute necessary requirement or prerequisite for a plaintiff to obtain profits, unjust enrichment, disgorgement profits in a trademark infringement case brought under that section of the Lanham Act. So this ruling doesn't apply to dilution, and it's still unclear as whether this ruling applies to false advertising claims, which arise under the same section of the Lanham Act that this was decided under, but were not specifically addressed by this decision. But it's an interesting and intriguing question that I raised at the beginning. The other thing I want to raise at the beginning about both of these two cases is for the Supreme Court having granted cert, it's interesting that in this one, it was a unanimous decision. And in Booking.com, it was 8-1 majority, which I find curious, given that you would think granting cert maybe indicated some sort of closer call in the Supreme Court justices' minds. But indeed, they came out once pressed upon the issues fairly, or unanimously in one case and almost unanimously in the other. The other common thread that you see in both these cases is, and this has been recognized by many commentators online, is that in each case, the Supreme Court of the United States rejected a bright line rule approach to the problem and instead opted for a more flexible approach. And I want to say a few words about that later. All right, so in Romag, the facts were as follows, again, in brief compass. Fossil contracted with Romag to use Romag fasteners in Fossil leather goods. And as I understand the facts, that meant that Fossil made leather goods, and they have on, wallets and on purses and other types of products they sell, a fastener that makes the item closable. And that fastener is not made by Fossil, but is supposed to be made by Romag. And I believe, though I should double check this, it carries Romag's trademark on it. So Romag discovered in any event that Fossil was using counterfeit Romag fasteners on its products, I believe made by a counterfeit entity in China. And so Romag sues Fossil, and let's see, did I get it right? Yeah, Romag sues Fossil and some of its retail sellers for, I see David Bernstein, my good friend here, saying, yeah, the fasteners did contain the trademark on it, which means they were public-facing, consumer-facing. And so the trademark owner here, Romag, sues the Fossil for counterfeit activities initially undertaken by a third-party supplier. And in this situation, the evidence, I guess, was competing, or there was variable evidence about whether, to what extent Fossil knew that was going on, and therefore had sort of that willfulness state of mind that would give rise to willful infringement for knowingly including counterfeit parts, or whether it just didn't do enough investigation or whatnot. And I believe the jury found in this case that it was not, there was no willfulness, and there was, however, a finding of so-called callousness, or maybe callous disregard of some facts that would have indicated that these were counterfeit. And the district court, based on this kind of situation of facts, rejected Romag's request for an award of profits because the jury found no willful infringement. And next slide, please, Kelsey, thank you. So the issue that went up on appeal was whether that was correct, whether that was the right ruling, whether specifically a damages award of the defendant's profits in a trademark infringement suit. And I put in there, some trademark lawyers understand right away that that terminology means a likelihood of confusion suit, not a dilution suit. Some people speak, more loosely about what a trademark infringement suit is, but this refers to a confusion-based standard trademark infringement suit. Necessarily requires a finding of willful infringement. And the holding is no, it does not. As I said, it's a unanimous Supreme Court holding. I believe Judge Gorsuch wrote the opinion for the majority. He has a background, as I understand it, in intellectual property law before, or maybe has some before joining the bench at the Supreme Court level. And so there had been a circuit split, and that seems to be the most obvious reason, or one of them, why the United States Supreme Court took the case. And so what do we know about this case? Okay, so we know the Supreme Court case. Next slide, please, Kelsey. The Supreme Court has resolved the circuit split and come down in favor of that group of circuits, and there were several of them, that had previously said willfulness is not necessarily required. By the way, I should note that the Supreme Court didn't say it's irrelevant to a finding of disgorgement. It's a significant, or I think I might have said important factor that ought to be considered by a judge or jury in making this analysis. So what was the court's reasoning? The court primarily, in my opinion, based its analysis, its holding, on the language in the Lanham Act. I looked at this as primarily a statutory interpretation case. As interesting as it is to think about it on a theoretical level, the court looked at the language and it said there's no reference to a requirement of proof of willful infringement in the Lanham Act in the relevant section in order to prevail on an infringement claim. And it also said, by contrast, as I note here in the slides, that under the dilution section of the statute, willfulness is required to obtain profits. So the idea, and you've all seen it before in legal reasoning, is that if Congress knows how to say something, like there has to be willfulness, and they don't say it, it creates a reasonable inference that they didn't intend to have that requirement in this part of the act. And that's a pretty powerful and often used and relied upon principle. So the court concluded that there was not willfulness as a requirement. But again, as I said, it stressed that it's an important factor. So if we could do the next slide, please. Impact of the decision. Well, this is where things get more tricky. Even preparing for today, because weeks have passed, if not months, since we did our original podcast with a couple of partners from the Orrick law firm in the trademark department on Romag. And we got right there into implications. And those lawyers thought, the case kind of looks significant at first blush, but maybe it's not. Probably it's not. And other commentators have agreed with that. And in fact, if you look on various blogs like IP Watch, you'll see a number of lawyers weighing in on what they think the significance or the impact of the case is going to be. And I've picked up a few that I'm not necessarily endorsing. It's sort of hard to say what the impact would be, but I just wanted to pass on to you some of the potential impacts that I've read and I think are, plausible for us to consider. So certainly the obvious one is this resolves the circuit split. And in those circuits that required absolutely a finding of willfulness, those cases or that finding a precedent is overruled. So that's an impact. The other items or factors or possible implications I've seen mentioned run the gamut. So one commentator who I thought was particularly insightful, he thinks, his name is Foster Garvey. No, he's at the law firm of Foster Garvey, Benjamin Hodges. I give a shout out to him. I don't know him, but I liked his analysis and I thought I would reiterate some of it here. He thinks, and I think tend to agree with this, that this will delay or complicate resolution of trademark cases because it removes and as he says, a route of summary judgment in those circuits that previously required willfulness. It seems very logical to me that if a defendant cannot easily move for summary judgment on willfulness and take the sting or the potential sting of profits out of the case, it could minimize a defendant's ability to achieve a more favorable settlement for itself at an earlier stage of the case by kind of, reducing the risk of a jury finding on willfulness and on, therefore, on profits. It changes the, potentially changes the, how would you put it, kind of the playing field of how litigation happens around this issue. And I think if it does so in favor of plaintiffs and to the possible detriment of corporate or just defendants of accused infringers. It's also clear, however, that willfulness or the state of mind of the defendant will continue to be an appropriate subject for discovery in these cases. And that raises the question of what is the law on willfulness? What is willfulness? And for better or for worse, it's a kind of a mushy concept, a flexible concept in trademark law, where you see some opinions on a very broad approach to it suggest that it could be something as simple as the defendant knowing of the plaintiff's mark, perhaps through a clearance search, and adopting its own mark anyway. All from that kind of knowledge plus conscious adoption, all the way to something much stronger, which is like evil intent to trade on the goodwill and perhaps siphon them off or divert them from the plaintiff to the defendant. And so I suppose a good practitioner has to keep her eye on case law in her whatever circuit she's litigating in as to how willfulness has been defined in the case law and how it can be used as a tool, even as a factor going forward in that circuit. I also think that this probably means, although we don't know this yet, that more plaintiffs will seek or at least aggressively pursue disgorgement damages as a remedy than they might have otherwise prior to, in some circuits prior to this holding. And as I mentioned, it could impact settlement and how people feel about that. I also picked up some, in reading, some more practical possible implications and takeaways, and I'll tick them off or just list them quickly because I want to move on to the second case and stay true to my word on and tight with my timer. One commentator suggested that maybe we ought to think as practitioners about cease and desist letters and whether a more explicit threat of disgorgement damages could be put into a plaintiff's cease and desist letter or a potential plaintiff's cease and desist letter right from the beginning, because this case arguably broadens the availability of those damages. Another possible implication for behavior and trademark lawyers is on clearance. Arguably, one could say that a trademark lawyer advising a client on the selection of a mark should be more careful and more cautious about picking a mark or endorsing a client's selection of a mark that could be confusingly similar to a pre-existing, already used or registered mark, and at least communicate to the client that the risk of liability is arguably higher because of the Romag case, and that therefore the cost-benefit analysis that goes into whether to choose a kind of iffy or borderline mark ought to be more carefully considered. Some lawyers would say, and have said to me, I already did that anyway with clients. I assume the worst case scenario because there already were circuits in the United States where willfulness was not an absolute requirement And usually when I'm advising my clients, I assume kind of worst case scenario jurisdictionally. And so I don't think it's going to affect my personal advising or counseling behavior whatsoever. I'm not sure clients will necessarily think that, but it depends, I guess, on where they are and maybe where they've been doing business. And so I guess the final question I ask about implications or issue I raise is whether it will increase the frequency of trademark litigation, because this adds kind of like whipped cream on the top of the ice cream sundae as something to obtain, at least across the whole United States, slightly more easily. Then the other question that I raised at the beginning is, what will its effect, if any, be on false advertising claims, which is interesting. It comes out, false advertising claims arise under the same section as the Lanham Act, but they weren't addressed explicitly anyway, in this opinion. So with that, I would like to wrap up my overview on this case and move on to Booking.com. All right, I took more time to do that than I thought I was going to do. And I really like this case. I'm sure a lot of you do. We had a record number of people. By the way, we had about 225 people register for this event. So thank you to all of you who registered. We had about, I don't know, we had like 700 people register for the webinar on Booking.com. I think it's a very interesting case in US trademark law. So the facts. The widely known Booking.com website and business sought trademark registration. If I remember correctly, it was in or about 2012. When you think about it, that's a long time for this to get resolved for them. By the time it got decided in 2020, it's like an 8-year, battle. But they sought it, and the USPTO said that it was not registrable as a trademark for an online hotel reservation service because it was a generic name for such a service. And the PTO said that they were adopting, although it wasn't always consistent from all of their prior decisions, they said they were, in my opinion, they said they were adopting a bright line rule or a per se rule or an almost per se rule. It's been described as that a generic word plus .com when registered for use or already has been used for that type of product is still a generic word or still a generic name, and it simply can't be registered. I'm going to look at my notes here to make sure I got the procedural history quickly. So the PTO said no. The TTAB, the examiner said no. The TTAB said no. It was appealed to Virginia District Court. The Virginia District Court said yes, it could be registered. The Fourth Circuit, as I recall, affirmed, and the Supreme Court ultimately affirmed the Fourth Circuit in an 8-1 decision, majority opinion authored by Justice Ginsburg, whom as you know, we know that she, I believe, lies in state right now as we're talking about one of her last opinions. But Justice Ginsburg, she looked at the case, and there were many, many factors in this case. I don't think I can sort of do it all justice here in the time I have. Kelsey, if we could go to the next slide, please. Kelsey, next slide, please. Thank you. The issue was whether Booking.com is generic and therefore unregistrable as a mark. And we already went through the procedural history. The majority says it's not a generic name. One of the reasons, there were a lot of facts in the case, including a survey by my colleague in the survey world, Hal Perret, that found something 76% of survey takers didn't see it primarily as a generic name, They saw it as a brand name. That survey was not explicitly addressed by the Supreme Court on appeal, but it was presented into evidence at earlier points in the case. I think it was important. The Supreme Court also, though, I think was anxious to reject the nearly per se rule against registering any or all generic .com trademarks or domain names as trademarks as too broad. All right, so this raises itself a lot of issues. One is, what is the scope of this opinion? Where does it go? How is it going to play out? What does it mean? And again, we see in the commentators and highly respected attorneys and commentators disagreeing about the scope of this opinion. On the one hand, there's a group of folks who think this is very significant and that it means that there could be, I guess when I talk about scope, there's two ways to think about scope. One is the scope of enforcement of this registration and of this right. Like how broadly could Booking.com enforce its rights against third parties? At oral argument, at various stages of the case, it stated on the record that it wouldn't seek to harass or enforce this right very broadly. But a right is a right is a right, you know? I don't think those kind of statements necessarily create a legal estoppel. I don't know. And it certainly doesn't necessarily apply to some other company that registers and obtains registration in a generic domain name. And so, you know, again, in reading about and thinking about scope and about implications, one view is, well, the Supreme Court didn't say that all generic .coms are necessarily trademarks. Just said they could be. Depends on the facts and circumstances of the case. I think that's the gist of the holding. But it didn't necessarily provide extremely helpful guidance on what that means going forward for trademark prosecution attorneys or for litigators. And so one trademark prosecution attorney that I saw opining on this online said, I really don't know what to do with this in terms of helping my clients get registrations for generic .coms now, if in particular, if they don't have a mark, a domain name that's been used a lot and has widespread recognition and, you know, secondary meaning, if you will, like Booking.com did by the time the issue came to loggerheads, to fruition. So for example, if somebody wanted to have sofas.com, forgive me if it already exists, I should have checked right before I did this, but let's say it didn't, and you had a client, they wanted to register sofas.com with an intent to use application, would this case help them get that through the PTO? Or would the PTO still be able to say, okay, there's no per se rule against registration, but come on, you know, there's a sofa.com site that sells sofas branded by 142 different companies is, I think, is maybe sort of presumptively not inherently distinctive. And then the question is whether it's, you know, how to categorize it. Is it descriptive and therefore capable of acquiring distinctiveness? Plausible, credible argument could be made for that. Or could you even make an argument that that it's inherently distinctive because there can only be one .com domain name, and so that signals arguably to relevant consumers and potential consumers a single source. And, you know, will that argument, that kind of argument, have any purchase going forward at the USPTO? And I think the answer is we don't know the answer to these questions about the scope of enforcement and about the application of this ruling at the Trademark Office. So, you know, there it is. My own take on it is timing made a difference. When this case came to fruition, Booking.com had grown into a very significant company with a lot of brand recognition that I think puts a lot of pressure on courts to protect reasonable investment-backed expectations. You could say they're not reasonable if you adopt a generic name, you're putting your money at risk on your own, but I don't think that was the common sense argument that the court accepted here, the High Court. No, I guess these are, given the times and where we're at, these are reasonable investment-backed expectations that we've got to look at realistically, and at least in appropriate cases, we have to allow registration for and enforcement of. We'll deal with enforcement scope on a case-by-case basis. So, but I don't think it means necessarily that everybody's going to run out and be able to register every single generic.com as a domain name, or necessarily to protect them as successfully as this company did. The question I also saw, and I'll end with this, by some commentators is, or lawyers is, what kind of evidence should I compile now if I go to the PTO? Do I need a survey? Do I need archival evidence? There was a lot of good evidence in this case to support brand recognition. What kind of evidence do I need to put together in a different case to support a registration? So with that, I will kick it back to Stephanie, and I'll be open for questions and comments at the end. Thank you.
Thank you, David. That was very interesting. And next we're going to go to Vijay Toke, who's going to talk about two general topics. The first being looking at a couple case trends in the lower courts relating to the intersection of the First Amendment and the Lanham Act. And then a couple cases looking at implications of pending US litigation for online platforms and platform liability. All right, Vijay, take it away.
Thanks very much, Stephanie. Appreciate it. And welcome, everyone. Thank you again. Actually, let's go to the next slide, please, Kelsey. So let me tell you about a little bit of what I'm going to talk about. And I apologize. David has such a wonderful cadence. I speak a little faster. I have a lot to cover. I'm going to try to make up a little time here as well. So I will be talking about three things, actually. The attorney's fees under the Lanham Act, the confluence of the First Amendment and the Lanham Act, and specifically the application of Rodgers. And I will finally be talking about platform liability like Redbubble and sort of the latest cases dealing with Redbubble. Next slide, please. So let's jump right into it with regard to attorney's fees. So a little background: what is an exceptional case under the Lanham Act? As we all know, that attorney's fees can be recovered under the Lanham Act for exceptional cases. Next slide, please. Section 1117 provides for that recovery. Post-octane fitness, a patent case, the standard is lower because the Lanham Act and the Patent Act actually use the same language. In fact, I believe that the Lanham Act borrowed the same exceptional cases language from the Patent Act. And so most circuits have adopted the lower standard in octane fitness, and a companion case from the Supreme Court that also lowered the burden of proof from clear and convincing to just a preponderance. So as you can see, most of the circuits have adopted the octane fitness standard to Lanham Act cases. Next slide, please. So what is the lower standard under octane fitness? Well, now, an exceptional case is simply one that stands out from others with respect to the substantive strength of a party's litigation position or the unreasonable manner in which the case was litigated. We're going to focus on the second part because I think the aspect of a case that simply stands out because of the strength of a party's litigation position is certainly intuitive. But to what extent can the unreasonable manner in which a case is litigated become an exceptional case and provide for the grant of attorney's fees? That's what we'll talk about. And under the octane fitness standard, we look at the totality of the circumstances of the case. And as I mentioned now, the entitlement to attorney's fees is not based on a clear and convincing standard any longer, but a preponderance. Next slide, please. So a case that actually our firm handled, we represented Comic-Con, San Diego Comic-Con, against an infringer. We won at trial, and in fact, were able to get an exceptional case finding and a grant of attorney's fees. Notably, at trial, the jury found infringement, but determined that it was not willful. So obviously, if we're an exceptional case, then we were not under the strength of the parties' positions, but it was really because of the pervasive bad faith litigation conduct of the defendants in this case. And on appeal, the defendants said, well, wait a minute, this was based on litigation conduct, and so it should, the attorney's fees award, which by the way was over $4 million and for all of our attorney's fees, shouldn't really apply according to the defendant and the appellant. And their argument was, well, if you're talking about a an exceptional finding based on litigation conduct, it should really be, the award should really be focused on just the extent to which those litigation tactics were going to, and it caused a greater cost to the other side. And there is some precedent for this. I've cited this case in Rembrandt Tech, where the Federal Circuit held that, well, a fee award is to be compensatory, not for wrongful conduct. For wrongful conduct, not punitive. And that's the part. But here, in our case, there was actually a finding by the judge that the litigation tactics were pervasive. They span from beginning to end of the case. And because they were pervasive, that the fee award was appropriate. And of course, it was an exceptional case, but because of the pervasiveness, it could actually cover all of the attorney's fees. And the Ninth Circuit affirmed. I think this is a really important case because now it can tell you if you have an opposing side that is pervasively acting in a way that from a litigation strategy is beyond just zealous advocacy, but instead is now bad faith litigation tactic. If that is pervasive, there may be the possibility of recovering all of the attorney's fees in the case, even if there's no finding of willful infringement. So I think this case is meaningful in this context. It's unclear how other circuits will approach this conduct-based fee awards, but the fact that the Ninth Circuit affirmed this award, I think, is quite significant. So let's turn on to the next issue. And next slide, please. Let's talk about VIP products versus Jack Daniels. This is the First Amendment versus the Lanham Act. The Ninth Circuit here has expanded the First Amendment further into trademark law. And this is a case that's currently pending, and we'll talk at length about this, but let's go to the next slide, please. Before we get into the discussion of this confluence of the First Amendment and the Lanham Act, I have a polling question. Should commercial products, and well, actually, let me go back to the facts a little bit before we get into the actual question. So in this case, VIP Products makes dog toys. And the dog toy in question looks like a Jack Daniels bottle. Actually, let's go to the previous slide for a moment, please. You can see the picture of the Bad Spaniels product on the left, which is the dog toy, and of course the Jack Daniels bottle on the right. Bad Spaniels dog toy is replete with lots of scatological humor, specifically canine scatological humor, like instead of old number 7 on the Jack Daniels bottle, it says old number 2. And there are various other similar types of humor on the Bad Spaniels product. VAPI Products actually files a deck relief action in Arizona. And ultimately, what ends up happening is the Ninth Circuit here holds that this is an expressive work for the purposes of the application of Rodgers versus Grimaldi. And we'll talk a little bit more about that, but here is the photo, comparing the two. So let's go back to the polling question. The big question is, should commercial products like dog toys be subject to the Rodgers test of the First Amendment rather than subject to a typical trademark analysis if they have some expression in them? So let's go over to your polling question, yes or no, and let's take a look at what everyone thinks. And I'll give you a few seconds to consider the question. All right, let's go 5, 4, 3, 2, 1. Let's take a look at the results. So, wow, that's interesting. It's split nearly 50-50, 45 to 55, slightly in the edge of no. There shouldn't be First Amendment protection for the for commercial products in this context, but a good percentage say yes. Interesting. All right. Well, let's talk through what the current state of things. So next slide, please. Okay, so let's do some background here. And so Rodgers versus Grimaldi is a case from the Second Circuit in 1989. It involved a Fellini film called Ginger and Fred about some struggling dancers impersonating Fred Astaire and Ginger Rodgers. Ginger Rodgers sues, claiming it Lanham Act claims and others. And the Second Circuit holds there's no liability here and creates a two-part test where we're talking about, where we're talking about the title of the film, Ginger and Fred. So the Second Circuit comes up with this two-part test. You look at whether or not the use of the trademark in question here has any artistic relevance to the use of the mark in the title of the expressive work. And if it does, whether the use of the mark is explicitly misleading as to source or conduct. Next slide, please. Now, the Ninth Circuit in Mattel versus MCA Records back in 2002 explicitly adopted the Rodgers test involving a case where there was a song Barbie Girl, and the court takes on the Rodgers test as if it were its own and determines here, well, yes, the use of Barbie in the name of the song so yeah, they were presenting and saying that in this particular case, there was use of the Barbie mark, it was artistically relevant, and therefore, and it was not explicitly misleading as to the source or content, therefore, this was appropriate. This was an appropriate application of Rodgers and also that there was no liability. Next slide, please. The Ninth Circuit again revisits another Mattel case. This one in Walking Mountain dealt with an artist who created a series of photographs which, as you can see, put Barbie in various compromising positions. And the title of the photos also included the term Barbie. And Mattel sues the Ninth Circuit. Once again, next slide, please. Actually, sorry, we'll get to ESS in a moment, but the court says, well, once again with Barbie, yes, there is in fact artistic relevance here, and it's not explicitly misleading as to source or content. Interestingly enough, the Ninth Circuit also in this case dealt with the issue of whether or not trade dress is at issue and whether or not the Rodgers test applies to trade dress claims. And the Ninth Circuit punts on the question and ultimately resolves those claims on fair use grounds. This will be interesting as we talk about VIP versus Jack Daniels a little bit. Next slide, please. Here's the Ninth Circuit. Then the Ninth Circuit actually expands Rodgers from not only the title of a work, but also to the content of the work. And so that's the important thing about this particular case. Let's go on to the next slide, please. The Ninth Circuit further extends Rodgers 3 more times. The first is in 2017 in 20th Century Fox versus Empire Distribution. There, that case dealt with the Empire television show on Fox, and the plaintiff, there actually Deck Relief defendant again, was a record company that actually had the mark Empire registered. The Ninth Circuit, not surprisingly, again, applies Rodgers to this circumstance with regard to the title of the Empire show, and even to the content to a certain extent. But interestingly, even extends Rodgers to the ancillary marketing of goods to promote the show. I think many trademark practitioners take some issue with that extension beyond the work itself. And in that instance, actually, Fox was actually allowing the download of music as well, which was an interesting part of this case as well. Next slide, please. The Ninth Circuit again applies Rodgers and extends its reach in Gordon versus Drake Creative in 2018. There, that dealt with the very famous Honey Badger, Don't Care, and the other one that's again a little bit scatological, and the very famous viral videos that are associated with that, with those marks. The Ninth Circuit has no problems, it says, determining that greeting cards are in fact expressive works. They convey messages, they have graphics and texts, and therefore this is an expressive work to which Rodgers applies. Next slide, please. And while the court acknowledged the greeting cards were not the highest expression of art, the First Amendment doesn't require that it be Anna Karenina or Citizen Kane, but instead it reiterated the Ninth Circuit's adoption of this rule that the level of artistic relevance needs just be above zero, and observing that the use of the mark was artistically relevant because the mark is the punchline in the cards. But the Ninth Circuit did reel back a little bit and say, well, but there were tribal issues of fact on the second question, because there was certainly some artistic relevance, but whether or not it was explicitly misleading was open to question and needed to go before a jury. Next slide, please. Now let's turn to the case at hand here, VIP versus Jack Daniels. Again, the Ninth Circuit holds that dog toys are expressive works. And I put this out to the people here, the attendees. Is a dog toy really an expressive work? Other circuits have really looked at this and have refused to extend Rodgers, in particular the Third Circuit. Others have only limited their holdings and application of Rodgers to traditionally artistic works such as television or art or books or magazines. So this is yet again another extension of Rodgers to another class of products. The Ninth Circuit goes on to hold that that the use of the Jack Daniels marks and trade dress were relevant to the expressive work and were not explicitly misleading. And with little analysis, the Ninth Circuit actually extends its holding on the First Amendment defense to Jack Daniels' dilution claim as well. Once again, let's revisit what I mentioned earlier, that in the Barbie Girl case with Walking Mountain, probably not the Barbie Girl, the Walking Mountain case, the Ninth Circuit did say, we have not reached the issue of whether Rodgers should apply in a trade dress case. The Ninth Circuit doesn't even address that in Jack Daniels, merely just sort of assuming that it does, or doesn't even focus on the issue. So that's an interesting aspect of that. And in the dilution aspect, the Ninth Circuit didn't acknowledge or analyze the prohibition on using the First Amendment or parody as a defense, which is explicitly limited to where the defendant does not use the mark as a source identifier in Section 1125C3A. The Ninth Circuit unfortunately denied rehearing en banc, but Jack Daniels has actually now filed a cert petition with the Supreme Court. We will see what happens. But this will be an interesting case to watch. Next slide, please. And there's also another case, Staphanie versus National Geographic in the 10th Circuit, that is also putting Rodgers front and center. Taufer, a filmmaker, sues, claiming that its Wild American Nature documentary series was infringed by Nat Geo's America the Wild, for a similarly formatted nature documentary series. On a 12v6 motion, the district court actually dismissed the claims. Now, the 10th Circuit hasn't actually adopted Rodgers, but the district court acknowledges that, but instead creates its own test. Next slide, please, which is kind of a mix of a likelihood of confusion analysis and a Rodgers analysis. So here the district court fashions this new test. Do the senior and junior users use the mark to identify the same kind of goods or services? To what extent has the junior user added his or her own expressive content? Does the timing of the junior user's use in any way suggest a motive to capitalize on the senior user's mark? Is there any artistic relevance? And has the junior user made any statement to the public or engaged in any conduct known to the public that suggests a non-artistic motive? This would be sort of the explicitly misleading sort of element. And has the junior user made any statement in private or engaged in any conduct in private that suggests a non-artistic motive? We'll have to see what happens with the 10th Circuit and whether it accepts the district court's test, creates its own, or adopts Rodgers. So the briefing should be done and completed later this year. But again, I know in this kind of context, other circuits like the Louis Vuitton case, the Fourth Circuit there didn't go to Rodgers and just used a sort of traditional trademark analysis. That's the state of things at the moment. We'll see where this plays out. Next slide, please. Last topic, litigation involving Redbubble. So for those that don't know, Redbubble is an online platform for artists to sell creative works on a panoply of consumer goods such as apparel, phone cases, notebooks, home goods, wall art, stationery, etc. Redbubble notably doesn't design anything, but its platform connects the artist subscribers with third-party manufacturers and shippers. So basically it manages all of that process of manufacturing and packaging and selling and delivering those goods to end consumers. Now notably the box comes with an invoice from Redbubble and I think even some packaging that indicates it's coming from Redbubble, although Redbubble again has no actual involvement in the manufacture, just facilitates the connection between the artist and the manufacturer and shippers. And Redbubble does notably have a system in place to take down any designs that infringe a trademark owner's rights. And they even have a more robust policing strategy as well if a particular mark owner is willing to accept that. Next slide, please. So what's the issue? Well, as many of you may recall, generally ISPs and web hosts are not going to be liable for infringement unless they're on notice and do nothing to police or end that infringement. So for example, we can look at the Tiffany versus eBay case, which many of us know, as well as the Viacom International case, similar types of cases, and compare that to Louis Vuitton versus Akanak Solutions, where a web host was actually held to be liable after receiving cease and desist letters from Louis Vuitton that it was hosting counterfeit websites. It did nothing and was held liable indirectly. So there are three cases that I'd like to talk about quickly here with regard to Redbubble. So Ohio State versus Redbubble, LTDB versus Redbubble here in the Ninth Circuit, and YGM versus Redbubble in the Central District of California. Next slide, please. So first with Ohio State. Next slide, please. Ohio State. So notably in Ohio State, which is now on appeal in the Sixth Circuit, there was no claim for indirect infringement. It was all direct infringement. So I think this is a really important aspect. So Ohio State sues Redbubble because there's a lot of apparel for sale on Redbubble that incorporates Ohio State's logo and marks. The court ruled that Tiffany versus eBay, upon which Redbubble largely relies, did not apply since at issue in that case was primarily eBay's alleged contributory, not direct liability. The court ruled that Redbubble did not actually use the infringing mark in commerce, as we know is required for infringement, because it did not manufacture the products, and as such acted more like Amazon as a marketplace, which has repeatedly been held not to be a seller for the purposes of infringement liability. The court contrasted the facts with those involved in Cafe Press, a similar type of business that actually does have some relationship with the manufacturers for the goods that are ordered. This was argued in the Sixth Circuit, and we're waiting for the decision here. So we'll see what happens on appeal. Next slide, please. LTDB versus Redbubble, another interesting case decided in the Northern District in July of 2019, now on appeal in the Ninth Circuit. I believe it's now fully briefed, and there will be oral argument in the upcoming months. So LTDB owns multiple federal registrations for the mark Lettuce Turn Up the Beat. It sues Redbubble for infringement. There are lots of different goods available on Redbubble incorporating this mark. Judge Seaborg granted summary judgment to Redbubble. Interestingly, the court didn't address use in commerce like the Ohio State case did, but rather focused on aesthetic functionality, in particular a case called International Order of Jobs Daughters, which I think many of us who are familiar with the case thought had died on the vine some time ago based on aesthetic functionality, where the Ninth Circuit held that there was no infringement for creating apparel using the plaintiff's emblem for its women's fraternal order because it was aesthetically functional. This is on appeal in the Ninth Circuit, and we'll see where this goes, and whether it goes to be remanded to address issues closer to those in the Ohio State case and the YYGM case that I'm about to speak about in a moment. Next slide, please. So this is the last case that I'll talk about. So the owner of the Brandy Melville mark sues for both direct and contributory infringement, as well as vicarious liability and counterfeiting. The court granted Redbubble's motion for summary judgment on direct infringement, ruling, just like the Ohio State case, that, that for very similar reasons, that Redbubble doesn't really have direct liability here because they're not actually an instrumentality of the infringement. They're not involved in the actual manufacturing and just facilitate the relationships. The court admits there are some differences from flea markets and being a purely online platform, but on balance, the court concludes there's no direct infringement. The court denied both summary judgment motions as to contributory infringement and counterfeiting, concluding that there were sufficient fact issues to try them. And so that's really interesting. We'll see whether this contributory infringement theory will actually be determined for liability. So the court also dismissed the vicarious liability claim because YYGM failed to provide sufficient evidence of any partnership, agency, or substantial control by Redbubble over the circumstances of the alleged infringement. So it will again be interesting to see if this case proceeds to trial and what happens with that. So that's the state of what's going on with platform liability. And I want to thank all of you for your time.
Thanks, Vijay. All right, last I'm going to turn it to Nick Aries, who'll be discussing a number of topics coming from the UK and the EU, including bad faith arguments as a tool in the EU, online infringement and platform liability in the EU, which will be a nice juxtaposition with what Vijay was just speaking about, and then practical steps for Brexit. Take it away, Nick.
All right, thank you. We're on the home straight, everybody. I was originally planning to finish my remarks at 1 p.m. to allow 15 minutes for Q&A, but that would give me 3 minutes, which I think is going to be a bit of a stretch, actually. So forgive me, I'll probably eat into a little bit of the Q&A time, but I will try and go quickly. Okay, let's start with bad faith. We can have the next slide, please. Indeed, we can have the following slide, I believe. And the next one. This is the Skykick case, which I expect some of you have heard of already and even had to grapple with. Just for a bit of context for the non-European practitioners, which I think is probably everybody, in the EU, we're allowed much broader specs, recitations of goods and services, as a general rule than in the US. And that's because there's no need for us to demonstrate use or an intent, a defined and evidenced intent to use in order to register the mark in the first place. So that has led to fairly broad terms being used and fairly broad lists of goods and services. So one question is, was this case going to change that practice? The second point is that clarity and precision is a basis, lack of clarity and precision is a basis for rejecting a trademark application. But once you've got it registered, it's not actually, weirdly, a ground for cancelling a registration. So if you've got these vague terms in your trademark, you can't use that to actually cancel a registration. Was this case going to close that loophole? The factual background is that you've got Sky, the multimedia, multinational, famous claimant, very, famously quite robust enforcement practices, taking action against lots of Sky formative marks. And here that's exactly what they were doing, suing Skykick, which is a cloud email migration and email management software provider. They were relying on marks that some of which were had a list of goods and services over 8,000 words long, contained things like fur coats and leather whips, but also crucially here, computer software. And Skykick said computer software is too vague and it lacks clarity and it's too broad, and therefore your mark's invalid. And it went all the way up to the highest court in Europe, the CJEU. And they were asked the question, is a lack of clarity and precision in that list of goods and services that a mark covers, is that a ground for invalidating a mark? And they said, look, it is a ground for rejecting a mark, but the legislator was very clear it's not in the list of cancellation grounds. So no, you can't cancel a mark on that basis. Next question was, but can you invalidate a mark on bad faith grounds if there's no intention to use the mark in relation to certain goods and services. And here they said, yes, if you can show that the mark owner was obtaining the right for purposes other than those falling within the functions of a trademark, in other words, indicating origin, and you can show there's these goods and services the mark owner had no intention to use in relation to, that is bad faith, and it can actually taint the mark and lead to invalidity. And finally, does that finding of bad faith, does it taint the entire mark and the whole mark goes, or is it only those bits in the goods and services list that you can show the bad faith applied to, the lack of intention to use applied to? And the answer was the latter. So it doesn't screw over the entire mark. It's just those bits and pieces where the bad faith is shown. But there are some quite significant implications of this. So some people engage in a practice of so-called defensive filings. They file a bit broader than the natural penumbra of protection of their existing business. Sometimes people just like to file broad terms and include those terms where there's not necessarily an obvious link to current and future business. There are two schools of thought about the impact of this case on that practice. The first is that not a lot will change because, after all, an applicant will still need to bring a cancellation action that involves time and money and inclination. They will have the burden of proof of showing the bad faith. And also it doesn't taint the whole mark. So the mark owner is only going to lose bits and pieces of their registration. The second school of thought, which is the one I subscribe to, is that if trademark owners do continue to use broad terms and go way beyond the natural penumbra of protection for their current and future business, they're creating vulnerabilities in two senses. The first is that they might end up delaying the registration of their marks, which they're applying for. And the second is they might impede enforcement. Let's look at each of those. So for registration, in some countries in Europe, for example, in the UK, you can oppose a trademark on grounds of bad faith as well. And of course, as we'll come to see at the end of this slot, UK trademarks are becoming more relevant now, UK national trademarks, because of Brexit. Everyone's going to need a UK trademark whereas they used to get away with just having an EU trademark. So for your UK filing strategy, you might find yourself being opposed on grounds of bad faith. And then on the enforcement, that could be impeded on kind of three levels. Recipients of cease and desist letters faced with broad and vague terms are going to reply more robustly. Defendants in infringement actions are going to bring counterclaims for invalidity, and even potential defendants who are well advised in potential future infringement actions could preemptively bring cancellation actions, which can lead to a stay of subsequently filed infringement actions. So quite a lot of tactics you can deploy here on these bad faith arguments. And there are certain terms, computer software, financial services, telecom services, where it's hard to envisage anyone ever really being able to show a valid bona fide intention to use across the full suite and breadth of what that might mean. So I think we can have the next slide, please. This is another aspect of bad faith, and it's the concept of evergreening. And this is, again, a bit of context. In the EU, although we don't need to show evidence of use right at the outset when we're filing, after 5 years, the mark becomes vulnerable to being revoked if it has not been put to genuine use in relation to certain goods and services. That's led to a practice known as evergreening sometimes, where people just refile the same mark every 5 years to make sure they still have something on the register where they don't need to show use to sustain the registration. And here Monopoly did that, or Hasbro did it with the mark Monopoly. They essentially refiled an old mark. They added in some bits and pieces of the specification, and the Board of Appeal in Europe at the EU IPO held that did amount to bad faith, and that's partly on the basis of the witness evidence saying that the mark owner said it was an advantage to be able to rely on a registration without having to prove use. That's a benefit to the trademark owner. Of course it is, but that was used as grounds for finding bad faith here, and the mark was cancelled in respect of all the duplicated goods and services that had been filed the first time round. Let's have the next slide, please. So really, it's just to be aware of this line of attack, whether you're on either side of the argument, plaintiff or defendant. There's really quite a lot of possible angles of attack you can now use along these bad faith lines. Interest of time, let's move straight on to the next topic, which is about trademark liability for online platforms. Really interesting, and we can have the next slide again, please. Really interesting to hear Vijay's remarks about the Redbubble cases, because these were cases brought against Amazon in Europe, where the brand owners were actually trying to say, yes, Amazon was directly liable itself for using the marks. And in a case in Belgium, a first instance decision, Louboutin actually succeeded in that argument. So there, the court found that Amazon was itself using the marks in the listings, the infringing listings, and that was across three kinds of scenarios. The first, where the goods were delivered and sold by Amazon, perhaps that's a little more straightforward. The second, where the goods were delivered by Amazon but sold completely by a third party. Amazon was just hosting the listing and delivering the goods. And the third scenario was where Amazon were delivering, the third party was both delivering and selling the goods, but the listing was sponsored by Amazon. And in all three of those, the court found that Amazon was using the mark in its own commercial communications, because it was playing an active role in committing the act amounting to use, and it had some level of indirect or direct control. That was partly because they found things like the marks listed under sections of the site called Amazon Fashion, Our Selections, Our Fashion Picks. It talked about the Amazon business price, the contractual terms between Amazon and the sellers made clear Amazon had ultimate decision-making power for how the listings appeared. They ran advertising like adverts for their own products, for Kindles and so on, off the back of those infringing listings. And furthermore, because Amazon was found to have played an active role in this act amounting to use, they were also deprived of the hosting defense, the kind of platform defense, because they were not playing a neutral role. Watch out for the appeal in that decision. It's currently going through the appeal level court in Belgium, but interesting case to watch. In Coty, this was a case about stocking. It's an infringing act in Europe to stock goods with a view to putting them on the market where those goods infringe. Amazon here was just agnostically warehousing third-party goods, and Coty had a go at saying, look, that amounts to infringement. And here the highest court said a company storing goods on behalf of a third-party seller without knowing that those goods infringe trademarks does not itself use or infringe the trademarks, as long as the storing company doesn't pursue the aim of offering the goods for sale or putting them on the market. There was a lot of discussion here about what the fulfilled by Amazon services mean, where the argument was they were getting very involved with preparing the goods, advertising them, dealing with the actual customers as well. But all of that was ignored, and they just focused on the core question. There's currently a consultation going on in Europe looking at actually revising the liability regime for platforms. Too early to say which way that will go, but just to put that on your radar as well. Let's have the next slide, please. And again. So super quickly, the UK has left. We're in a transition period that ends at the end of this calendar year. The Brexit impact on IP rights is quite straightforward for patents, trade secrets, and copyright. Basically, there isn't really much of an impact. But for registered EU trademarks and registered community designs, the EU-wide unitary rights, holders of those rights will automatically and for free get a comparable UK national right spun off that EU-wide right. So that's all well and good for your existing registrations. There are one or two things you need to be aware of. If you've got pending applications at the date of Brexit, you're going to need to refile them in the UK. Have a think about your representation in the EU and the UK. UK practitioners after Brexit won't be able to represent clients before the EU IPO for EUTMs, apart from in ongoing proceedings that were already ongoing at the date of Brexit. Likewise, foreign practitioners, so European practitioners who aren't in the UK, weirdly can represent clients before the UK office for a period of 3 years after Brexit. But there is a question about whether their advice would be subject to privilege, so have a think about that. Look at your dispute profile at the EU IPO, because any disputes which are founded on UK national registrations or unregistered rights will fall away. Look at your trademark related agreements, licenses, coexistence agreements, settlement agreements. Look at the definition of the territory. If it's the European Union, you've got to go through an exercise of construing the contract in accordance with the governing law to see if that continues to cover the UK. Think about your customs recordals if you're a consumer goods company. If you've made a European-wide customs recordal of your rights via the UK, it will fall away. You need to refile it via a continuing EU country. Any litigation will have to be filed in both the UK and continental EU if you want to and make sure you're enforcing rights in both locations. And lastly, there's a complication around exhaustion where there'll be an asymmetry as between the way goods are treated coming from the EU into the UK or versus the UK into the EU. I don't have time to really go into that, I'm afraid, on this particular session, but you can ping me if you're interested in that particular question. We've got just a handful of minutes left for Q&A. I'm going to throw it back over to you, Stephanie.
All right, thanks, Nick. And yeah, we have just a few minutes left. If all the panelists want to hop back onto video and unmute. Nick, I wanted to ask you a really quick question while you're on, which is, does Booking.com come out the same way in the EU or in the UK?
Yeah, in the EU and the UK, there's a pretty bright line that the .com and any other suffix like that is entirely non-distinctive and can effectively be ignored when you should just assess the bit that comes before it. But there are cases like sportsbetting.com and muslimheritage.com where they fell foul of the descriptiveness and non-distinctiveness criterion. There are a few cases where adding the .com might change the distinctive character. We did manage to get lastminute.com registered, but that was on the basis of being able to show acquired distinctiveness through use.
Got it, thank you. And then David, there was a question posed to you in the Q&A box from Neil Smith asking, as a result of the Romag case, do you see juries having more issues to decide and a greater role in determining damages?
Yes, I do. In those circuits, at least where this wasn't the rule before, I think it's almost it's a logically foreseeable impact that I think it will occur. Happy to hear from the rest of the panelists if they disagree, but it's speculative, you know, by its nature. But it seems like it almost was the intention of the Supreme Court to allow for that to happen. Certainly they understood that would happen.
And then in our last couple of minutes, I wanted to pose to each of you the polling question that Vijay asked on the Rodgers expansions in the Jack Daniels case. Since we weren't able to vote, I'll just go ahead and start with you, David, and then Vijay, and then Nick. Do you guys think commercial products should be protected by the First Amendment or subject to typical trademark analysis? David, I'll start with you.
You want to start with it? Well, I'm glad you asked. I wrote a paper a few years back with one of my former students entitled, it was for the right of publicity, but there's some analogous reasoning, I think. The right of publicity and the First Amendment, towards a paid for First Amendment. It was meant to be provocative. The idea is, so my answer to the conundrum raised by the polling question is, you know, there definitely are works that are more expressive than others. I feel in trademark law, they feel like there ought to be able to assert First Amendment defense, even where there's a commercial motive. Because there's clear US Supreme Court precedent saying a dual motive doesn't, certainly in copyright law, doesn't strip the defendant from a fair use defense. Applying that over to the trademark situation, you would say, okay, it doesn't necessarily strip it. So in that, if that's the case, you have to say, yeah, they should, accused works that have expressive elements, whatever that means, ought to be able to assert First Amendment arguments, including in the one that was given as an example. What I think is troubling for me and for a lot of people is, yeah, okay, maybe you have a right to not have an injunction against you because of the First Amendment, but does that really mean you shouldn't have to pay a reasonable licensing fee for your free writing on the plaintiff's goodwill and product? Why is it winner take all? And perhaps one reason why it's become winner take all in trademark First Amendment litigation is because we don't have a trademark fair use doctrine in the United States that is akin to the fair use doctrine for copyright law.
Right.
And maybe if we did, we could deconstitutionalize this issue, consider questions that aren't really free speech questions in my view, like how much money is the defendant making off of their Jack Daniels, their use of the mark versus their own creative, humorous or value, and then say there's going to be an apportionment. And that could come from the judge or the jury.
That makes
and
sense.
I think, but nobody's adopted it. It's just professor talk.
Vijay, what do you think?
My view is I think there's some danger in applying Rodgers to any particular kind of any commercial product that happens to have some expressive aspects to it. Because it really shunts you out of a likelihood of confusion analysis and into a very heavily First Amendment oriented test that is Rodgers. Even the Second Circuit, for example, has sort of refined this test a bit in the Twin Peaks case, saying that you apply likelihood of confusion as the second factor, and if it's a particularly compelling likelihood of confusion, then you can still find liability. But that's even assuming that you're dealing with an expressive work. I mean, Rodgers was really about the title of an artistic of a movie, right? I mean, and most circuits have applied it that narrowly. And in fact, the Third Circuit held it was a publicity case, but really cautioned against applying Rodgers really broadly. So I think it was I want to say it was the Hart versus Electronic Arts case, and the Third Circuit basically said that it was very concerned that Rodgers is a very blunt instrument, unfit for widespread application in various cases that require a really carefully calibrated balancing of rights of free expression with trademark rights, basically. And so I think we have to be wary of applying Rodgers so broadly to any kind of product that has some modicum of expression within it, because clearly, and because there's also some level of taking that into account with the likelihood of confusion factors already. So that's my view, because I think otherwise everything becomes a Rodgers analysis if you've got even just a modicum of arguable expression within the commercial product.
Makes sense. I'm conscious of time, but I want to give Nick a shot. Nick, you're welcome to answer it from either a U.S. perspective, or I would also be curious how courts in Europe might be thinking of this, considering there's not an analogous.
I'll try and be brief. It would be dangerous for me to try and answer this on First Amendment grounds, given I'm not a US lawyer. I didn't see either of those answers on the poll, by the way. In the EU, those arguments would get pretty short shrift. I think we have a Charter of Fundamental Rights and we have a Convention on Human Rights, each of which protect freedom of expression. That includes commercial speech. So, for example, that can come into into play with comparative advertising cases. But here, I think this sort of case is the proper preserve of trademark and kind of passing off law, and I think you'd be looking if a defendant can escape liability on those grounds because no one's really going to make a connection and there's no dilution or free riding, they should get away with it. But I don't think a freedom of expression argument would carry them very far in Europe.
Yeah, that makes total sense. Yeah, I think as these cases get harder and harder, I tend to think the likelihood of confusion analysis can handle it, can answer the question without even needing to go into the First Amendment stuff with these more borderline cases. But that's just my view. Anything, we're about 5 minutes over, so I don't see any other questions that have come in. So I think, thank you everyone for attending. We had great turnout numbers. Thank you, David, Vijay, and Nick. I thought this was excellent. And thank you to the McCarthy Institute and to the SFIPLA for co-hosting. Really appreciate it. Thanks, everybody.
Thank you, Staphanie Hall.
Thank you, Stephanie.
For your
Appreciate
great
it.
Thanks, Stephanie. Thanks, everyone.
Okay, take care.
Bye,
Bye-bye.
everyone. Thank you.
Bye, everyone.
Bye-bye.